Can you make your client responsible for the belligerent, violent, or ridiculously stupid conduct of a wedding guest? Find out today on the podcast.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. We're going to have a fairly quick episode today. We are going to be talking all about the legality of making your client, that is the couple, responsible for the egregious conduct of the wedding guests and what all that entails and all the entanglements that come along with that. But first, my one ask for this episode, it's been the ask for probably the past few months now, and that is to please subscribe to my YouTube channel. Pretty please. I will be your absolute best friend. So go mosey on over to my YouTube channel, hit the subscribe button. If you have any type of requests for content, if you got any questions, leave a comment in the video down below. I promise I get to every single question in a podcast. I might not get you the following week, but if you got some type of question or you want something covered, I promise you that I will cover it. Well, as long as it's legal. I don't want no crazy stuff. But anyway, that's my one ask for the episode. So let's get into it. Now, you as the wedding professional, you want to keep yourself, you want to keep your staff, and you want to keep your stuff safe, okay? Because there's always going to be some touchy-feely groomsmen. There's going to be a drunk uncle. There's going to be some moron that wants to drop the mic and destroy your $1,000 microphone, okay? So if you didn't have a contract with your client, what can you do in these situations, okay? Typically, if someone commits some type of tort, like if somebody starts a fight with you, if somebody, we're talking about somebody, we're talking about the guest. If the guest pushes you against something and, you break your equipment or grabs you on the behind, whatever the case may be, typically that person is going to be responsible for their own behavior, meaning after the event is over, you can sue that person for the damage to the equipment. You can sue that person for assault. The person themselves would be responsible. There is a possibility in those situations where there's no contractual obligations that you could bring the couple in. There are theories of law that might allow that depending on the facts of the situation. For example, if the couple knows that the person is getting drunk, XYZ, we won't go too far into that. So yes, at the end of the day, you would finish the wedding, and then your action that you could take would be to sue that person, the guest, at a later time for whatever they did, okay? But in those situations, though, the rub with the law is, depending on what happened, you would still have to continue to fulfill your obligations under the contract. So if some moron bumps into you and breaks a piece of your equipment, touches you on the butt, whatever the case may be, there is a legal theory that says that unless you're going to the hospital or something, you need to continue with the contract. Otherwise, you may be opening yourself up to a breach of contract by the couple. So there's going to be a spectrum of, if the conduct's so egregious that you couldn't continue, all the way down to it's not so egregious and you got to keep going, and there's going to be everything in the middle. So there's a possibility that if you were like, you know what, forget this, I'm not going to get into a fight with drunk uncle, I'm leaving. Like, I would rather just leave than get into a fight with drunk uncle. Well, that's a possible breach. You're going to be a possible defendant in a breach of contract action if you do that. Okay, you are a potential defendant in a breach of contract, meaning the couple could possibly sue you because you left. Okay, depending on the facts of the case, you might lose or you might win. Okay, so you don't necessarily have the right to leave the event necessarily if one of the attendees is out of hand. Okay, so how do we make it then? If it's not automatic, how do we make it the client's responsibility? How do we make guest behavior the client's responsibility? And that is through the contract itself. So let me, before we get into the super nitty gritty into this, there's a concept in this that I want you to understand, and it's going to be the reason why it's super advantageous to make the client responsible for the attendee's conduct. And that has to do with the concept of material breach of contract. So I've talked about this in other hot takes and in other podcast episodes. If you don't know what a hot take is, check out my YouTube channel. I do hot takes, I don't know, maybe once a week or so about current events. And I know that about a month ago, I covered, at least a month ago, I don't remember, just check it out on the YouTube, but it was a hotel in which a wedding reception was taking place and the groom sexually assaulted a server. So my hot take on that, I covered a little bit of material breach versus not material breach. But anyway, all right, as far as this goes, typically, if you do something as the wedding professional that is not in line with the terms and obligations of the contract, then technically that's a breach of contract. So for example, if you're 5 minutes late, 20 minutes late, if the flowers that they were supposed to get are slightly a different shade of red than they should be, that's a breach of contract. There are many different ways that you can breach the contract. The reason why typically you don't hear about them in the law is because although that is the genesis or the reason why somebody could sue you for breach of contract, at the end of the day, they have to ask a court for money damages based on that breach. And if you're 10 minutes late and it doesn't affect anything, then even though you're technically have breached, the jury or the judge would award that person $0 probably. It would be a nominal amount. Okay. So I say this because whenever there's a breach of contract, it doesn't necessarily mean that the parties have to stop doing what they're supposed to do, that their obligations stop. In other words, if you're 10 minutes late, it doesn't mean that the client doesn't have to pay you anymore. It doesn't mean that the client doesn't have to keep doing what they're supposed to or that you have to keep doing what you're supposed to. Okay? Everybody keeps going, even though it's a breach of contract. Now, there is a concept in contract law called material breach. And when there has been a material breach, that often discharges the other party's duties and obligations moving forward. So if you have, if by way of example, the client has made time as of the essence for you to get there, a material breach, meaning that if you're 1 second late, that's a material breach. Then if you showed up 10 minutes late, then there's a possibility, if the wording is correct in that contract, that they would not have to pay you. Okay? Something along those lines. I don't want to get, too into that. But that's the basic concept. If you have outlined a particular conduct that is a breach of it's a breach of contract, that is a material breach, then typically you're discharged from further obligations. You're discharged from further obligations. So what this means is that you could design your contract in such a way as to say, client, you are responsible for the conduct of the guests. You are responsible for the conduct of the guests. If the guests exhibit any type of, and you can name your litany of behavior, aggressive, sexually inappropriate, harassing behavior, belligerent, whatever the case may be. Here is the degree of conduct that will that would be unacceptable if exhibited towards me or my staff. This is the conduct that would be considered a material breach. You define whatever the client's conduct that you want it to be material to the contract, your continued performance as material. And you let the client know through your contract that behavior will mean that if it occurs, then you're out of there. You're going to take your ball and go home. That way, it's not a situation where, a drunk groomsman grabbed my boob, but I gotta keep serving him tater tots. No. you can leave. You would be within your rights if your contract is spelled out correctly, that that's material breach. It discharges my further duties to serve you tater tots, and I can leave. Okay. So you are within your rights to do that within the contract. There's a couple caveats with that. The first caveat is that if you want to be safe about it, if you want to be the absolute safest, because being touched on the boob is egregious, and I think that there's probably not going to be very many courts that's not going to say that's a material breach. It's everything before that. Everything before that could be a potential. So the caveat is if possible, you want to give the client the ability to mitigate the issue. So in the contract, here's my litany, here's the list of things that are not going to be kosher with me. I'm going to give you one chance. I will approach you and give you notice that this conduct has happened, and if it continues to happen, this is what's going to happen, which is we're going to leave. So you define the behaviors that you don't want. You give, depending on the behavior, the client the ability to mitigate the issue. And if it's not mitigated or if it continues, then you're discharged from further performance because it's a material breach. So it's not as hard as it sounds. The law is pretty intuitive when it comes to this kind of stuff. Essentially, you are making this individual that you're signing the contract with responsible for everybody's behavior. Okay. So the other caveat to this, guys, is look, if something bad happens to you or your staff at an event, don't worry about the contract. Call the cops. If somebody, punches you in the back of the skull or sexually assaults you, call the police. Call the police. Like, I don't want this to be some type of thing where it's like, well, Rob said that, I got my contract here and I got to keep going or whatever. Or even if you could leave, I don't care. If something has happened to you and you're not comfortable and it's a criminal act, call the cops. Okay. But otherwise, you should have your contract available for them to see that they're responsible for them. One of their attendees has committed the behavior that's wrong. You've let them know that it's wrong. They've continued to do it. You're within your rights. You've reserved your rights to be discharged from further performance, and you take off. And that should mean that you theoretically would not be a defendant in a potential breach of contract action, because now you've brought the client into the orbit of what the attendees are doing. The other thing I would say is, even if all that is the case, even if you have the contract, even if you're within your rights to leave, that doesn't mean that you still can't sue the attendee for whatever tort they've committed, if that makes sense. I'm just saying that in your contract, you make it the client responsible because it allows you with less risk to leave. Under the contract, you leave. Okay. That doesn't mean that you leave and everything's done. You can leave, call the cops and sue whoever the person is for whatever they did. I hope that makes sense. I think the main principle is that you want your contract to be able to say that you can be discharged, and you spell out the reasons why that is so. I hope that you found this helpful. Again, if you want a little bit more in-depth talk about this, go check out my hot take on YouTube about this. I can't remember the exact title. I think it's like sexual assault in wedding venues or something like that. So there's not too many of the hot takes on there. So check that out. And while you're there, please subscribe. I would greatly appreciate that. Hit me up on Instagram. Hit me up if you have any suggestions for content. I'm a sucker for feedback, so just let me know. And I guess that'll be it for this week's short episode. And with that, we'll see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.